introduction, I leave the work to Professor Rosenkrantz.
Thank you. I'm delighted to be here. Thank you, Jordi and Leo, for bringing me once again to this wonderful place. I'm also delighted to be commenting on Jules' work. As many of you know, Jules was my doctoral supervisor, and he didn't listen to me, so now he will have to listen to me. I had to listen to him, but now he has to listen to me. Commenting on Jules' work, it's an interesting but difficult endeavor, because it's like fox hunting somehow, because Jules always has a turn or a twist or a further distinction. I'm not into the fox hunting business, but I imagine if I were into the fox hunting business, I would go to hunt with a shotgun machine and you know, shoot a lot of to the core of the fox, and that's precisely what I'm trying, what I will be trying to do here. Shoot at what I think is Jules' most important conviction, which is, I think, that the tort law is about correcting wrongs. For Jules, wrongness is the bedrock concept of torts and corrective justice. Both the annulment and the mixed conception assume that only those losses that are causal consequence of actions that are somehow wrong should be the subject matter of corrective justice. Jules says only wrongful losses fall within the ambit of corrective justice. I doubt that wrongfulness should occupy this central role, and most of what I will say here is due to that conviction. Corrective justice does not operate in the void. It exists in a normative background inhabited by a complex set of norms and principles fixing what we had to do and what we had to avoid, and thereby establishing the distribution of things we value. If so, it is natural to see corrective justice as remedial to the unauthorized alteration made to distributions. Corrective justice then corrects wrongs made to rights to distributions, or for simplicity, wrongs to distributed rights. Coleman endorses this idea. He claims that the wrongfulness required by corrective justice must consist in departures from norms and rights that satisfy the condition of being worthy of protection against infringement by the action of others, even if they would not be protected against infringement by state action. But is this view that says corrective justice as remedial of the current distribution of things we value correct? Is the violation of distributed rights what explains entirely why we had to be compensated? Is it correct to claim that corrective justice is a response to wrongs generally? Well, you may think that distributed rights, paradigmatically among them, property rights, imply the right to be compensated for the violation. For instance, you may, but I doubt that's the case. For instance, you may have full ownership over your car, but you cannot argue that compensation is due to you for harm suffered by your car when I destroy it in order to prevent your attempt to run me with your car. To be entitled to ask for compensation is something additional to being the owner of the car is needed. Furthermore, ownership is an apocopated way of referring to a compound of rights to possess, to use, to destroy, to prevent, and to exclude others of the things we have, but neither the compound of rights ownership consists in, nor each one of the compensation is not logically part of the compound rights consisting, then the view that corrective justice response to wrongs cannot be explained just by reference to meaning of rights, or as Jules sometimes put it, to syntax. But you could offer sort of substantive or arguments for this view. For instance, John Garner has done so. He says that, for instance, if we break a promise, our general obligation to honor promises continues to exert impression on us to do something as close as possible to perfect performance of the promise we utter. This is so, John claims, because the reasons that sustain the general obligation to honor our promises also sustain the obligation to mitigate the consequences of breaching our promises. Those reasons not having been satisfied by performance of primary obligation, he says, are still with us awaiting satisfaction, and since they cannot be satisfied by performance of that obligation, they call for satisfaction in some other way. This is what John calls the continuity thesis. Jules seems to subscribe to this argument too. In the normative structure of tort law, he says that the reasons to explain the duty to repair is the nearest best alternative to taking the care necessary to avoid damaging the victim's property. I'm inclined to think that a continuity thesis is plausible in general, or a principle, but I'm sure that I cannot be required job of showing that corrective justice is a response to the violation of distributive rights, since it cannot sustain the idea that the right to be compensated is implied by the very meaning of rights. Suppose that I justifiably broke my promise to pay my kids to the beach today. Use the example John labors. I may have reasons to do something tomorrow to alleviate the frustration that I may have caused to my kids today by breaking my promise. But my wife will also have reasons to do something equally or similarly remedial. This fact, the fact that my wife also has reasons to remedy the situation I created, shows, I think, that my obligation to do something to alleviate the frustration of my kids does not derive from the wrongfulness of breaching my promise to pay my kids to the beach today. If that were so, my wife would not have any reason to remedy the frustration I caused, since she didn't run anywhere. And if at all, but rather from the factual condition my breaching has created, more precisely, the frustration of my kids. But even if I'm wrong, and I have special reasons to do something for having dishonored my promises, this reason I think lacks the specificity required, to ground the obligation we're talking about, because it may turn into, my obligation to apologize for not taking my kids to the theater movie, or take my kids in some other occasion, or give to them compensation I cannot derive from the fact that I broke my promise captain did infringe the dock owner's right. By keeping the ship moored to the dock, he argues, the ship's captain infringes the dock owner's right and commits, in this sense, a wrong. For Jules, there are two kinds of duties we could breach, two different ways in which we could commit wrongs. First, duties not to unjustifiable or impermissible injure others' legitimate interest, and second, duties to neither violate nor infringe other rights. Coleman uses this distinction between a wrongful wrong and a justified wrong to observe that even when we may not see at first sight, there is wrongfulness in cases like Vincent. He claims again that by keeping the ship moored to the dock, the ship captain infringes the dock owner's right and commits, in that sense, a wrong. But it seems to me that in Vincent's there is not all things considered reason for the ship captain to do otherwise than to dock the ship to the dock. Coleman shares this conviction, and that's why he claims that the wrong of the case is a justified wrong. But further, it seems to me that there is no reason whatsoever for the ship captain not to dock the ship. Indeed, as the court suggested in passing, it would be wrong for the dock owner to undock the ship, which, if correlation holds here, as I think it does, it necessarily entails that by docking the ship owner did neither violate nor infringe any of the dock owner's rights. There's certainly loss in the case, but not a wrong. When we claim that there is a wrong, we presuppose that somebody should have done something different than what she did, or that an action shouldn't have been performed because there is an all things considered reason, or at least a pro tanto reason, or a feasible reason against that action being performed. Since in Vincent there's neither of these two kind of reasons, the ship owner couldn't do any wrong. Furthermore, in Vincent, not only no action shouldn't have been performed, but given the background of the case, nothing shouldn't have happened. Docking the ship was the only means to save the more valuable the ship vis-a-vis the dock, and thereby an absolutely necessary step to avoid undesired consequences, all things considered. If the ship owner should not have acted differently, and the docking of the ship was a result we shouldn't avoid, how could we see that the wrong happened, or that a right was infringed, as Jules claims? Now, well, many people think that cases like Vincent create some discomfort by those that take wrongfulness at the court of corrective justice, but they cannot imagine that you could build up a conception of corrective justice without wrongness at the court. The argument against Jules couldn't be complete unless you gesture that such a conception is possible, and I would say plausible. So it is possible to articulate a conception of corrective justice without wrongness at the pivotal role. We know that the dock owner has to be compensated, and that the ship owner, and only she, is the one who has to pay compensation. The reason that grounds both aspects of this assertion, more precisely that compensation is due and that it's due by the ship owner alone, is not, as Jules would be inclined to say, that the ship owner and only him violated or infringed the dock owner's rights. The reason, rather, is that the dock owner, the reason why in Vincent the dock owner has to be compensated is that the ship owner and only him caused the dock owner's loss. Pretty theoretically, we are all convinced that causation matters. When A causes herself harm, either willingly or non-advertently, we naturally conclude that there is a powerful reason for A and only for A to bear the harm caused since she caused it. Similarly, if A causes B's harm, either willingly or non-advertently, strong reason to sustain that A and only A has to bear B's harm. Now, why is this so? Why causation matter? I think outcomes should be ascribed to us when we cause them, not just because history, identity, and character, as Honore once suggested, matter to us, but because they should matter. Leading a life where our actions impact our future, where we afford the cost and realize the benefits of what we do, is a better life than the one where we attain that. A better life than the one where what we attain in life remains insensitive to our doings. We care about causation because we care about our response to freedom. Now, this idea is attractive, but obviously has encountered a strong academic resistance. Many lawyers and theoreticians believe that causation at the bedrock for a conception of corrective justice, difficult problems will arise that can only be resolved at the cost of reintroducing wrongfulness. Coleman, for instance, after analyzing some of these alternatives or projects, states that reliance on wrongfulness as a condition of justice and recovery once again puts the defense of strict liability in doubt. The nature of the problem that arguably causation cannot solve by itself are basically twofold. On the one hand, there are problems that flow from the theory of causation itself, and on the other, problems arising out of the theory of responsibility. Perhaps in the simple case, the question of who caused what is easy to untangle. But that doesn't seem to be so in complex cases. For instance, where A, C's, D's, E's, and F's causal contribution to the harm of B are all sine qua non, the harm would not have occurred without them. Our pre-theoretical knowledge of causation would most likely not be enough to single out the cause of the harm. To progress in the ascription of outcomes to those involved in the case, we need a theory of causation, and it's just, the critics argue, impossible to articulate a theory of causation without making normative judgments, ultimately referring to what is that we have to do and what is that what we have to avoid. If this step is unavoidable, the whole project of articulating corrective justice around causation alone will collapse, because whether A caused B's harm, for instance, will be eventually determined by whether A did something she should have avoided, or whether she did not do something she should have done. Precisely the idea that lies at the center of the conviction of corrective justice as a remedy for wrongs. But this step, I think, is not unavoidable. We can articulate causal ascriptions without resorting to normative judgments, ultimately referring to what is that what we have to do or what is that what we have to avoid. Think again in the case where A, C's, D's, E's, and F's causal contribution to the harm of B are all sine qua non. The skeptics asserts that to ascribe outcomes to any of the parties involved and conversely to make final causal ascriptions would need to use the in the end or normative criteria determining what people can legitimately expect from one another to be provided by norms setting out our rights and obligations. But that cannot be so. If to assert who causes what, we have to rely on norms setting our rights and obligations, as the skeptics argue, by transitivity, what we do, which is determined by what we cause, will also depend on norms setting our rights and obligations. Since this conclusion is ridiculous, what we do cannot depend on what we have to do, and what we do is undoubtedly determined by what we cause, the idea of the skeptics that who causes what depends on norms setting our rights and obligations has to be rejected, and if so, the plausibility of the project of conceiving a conception of corrective justice where causation is what matters most could be reestablished. The second problem is a problem that arises out of the theory of responsibility. Imagine that this is an example, easy example that Jules works with. Imagine that A and B compete fairly in the marketplace. Nobody cheats. But A is much more productive and cheaper than B to the extent that A sends B into bankruptcy. Well, we all know that A is not responsible in the sense that it doesn't have to pay for B harms. And this conclusion obviously could be easily sustained if we could claim that A did not cause B's harm. But let's assume ex arguendo that A is the cause of B's bankruptcy. Now, if that were so, in the frame of the conception of corrective justice I hereby propose, A would have to compensate B, something we are not willing to accept. Jules suggested to avoid the plausible conclusion that A has to compensate B, we have to use what he calls the right thesis. For the right thesis, to harm is to violate or infringe a right. The right thesis, Coleman says, is a distinct theory which establishes that liability and recovery, I'm quoting here, are for rights invaded, not for harms done. Since A neither violates nor infringes its right, she does not harm B, and as a consequence thereof, she cannot have the obligation to compensate B. Thus, the right thesis, Coleman concludes, can provide the needed defense of the theory of strict liability. But the right thesis is a sort of Trojan horse. If the parties of causation and strict liability accepts it, she's lost. The right thesis presupposes that compensation is morally due only when and if you violated someone's rights, and thereby reintroduces the distinctions between what we had to do and what we had to avoid as the basic element of the conception of corrective justice. But when our concern for causation stems from the idea of responsible freedom, I think we could offer a principled way that explains why A should not compensate B for B's bankruptcy without falling back into the domain of wrongfulness. We could claim that A should be obliterated from compensating B because liberated from compensating B because her liberation is a sine qua non requirement for the existence of a practice or institution that help us to create the conditions within which responsible freedom could be most likely maximized. The kind of rule utilitarian argument I'm here using to restrict the scope within which compensation is due, inspired by the structure but not the substance of Thompson's arguments, does not undermine causation as the guiding principle of liability. And it's not, like the right thesis suggests by Coleman, parasitic on rights. What liberates A from B's demands here has nothing to do with A's rights to compete with B in the market or B's right that A doesn't compete with her, but it related to something altogether different, more precisely the conviction that it's better both for A's and B's responsible freedom, the value behind our appreciation of causation, that E be so liberated. Thank you.
Thank you.
Thank you very much for your paper. Now, of course, Professor Coleman will reply, and then we can open the debate to the other professors.
Thank you. Thank you, Carlos. It's so nice to see that all my students feel free at some point to criticize. That point is usually early in their relationship. Never ends. But actually, okay, so let me start by two things. One is, if we just focus on tort law, for example, we could think about tort law from in three different ways, two of which, well, probably a million, two of which are non-relational and one which is relational. The two of which are non-relational begin either, say, with the defendant or the plaintiff. Let's start with the plaintiff side. You might think that the annulment thesis, at least part of it, was looking at, from the point of view of the victim, have I suffered something that needs to be remedied? And the fundamental question is, if there's something I've suffered that should be remedied as a matter of justice, how should we go about doing it? Okay? So it's like, I don't own this misfortune. This misfortune is not something that should land on me. That's the first question. It's a question about, what the bad luck happened to me, is it mine to bear? Right? Then you can look at it from the point of view of the injurer, and you can view it from the theory of responsibility from the point of view of the injurer, which is, what are the conditions under which I'm connected to misfortunes in the world that make them mine to bear? Right? Where the question just is, whose is it to bear? And on the defendant side, you might think the answer to this is, when the conditions of responsible agency are met, it's mine to bear. If I'm connected to the loss in the right way, it's mine to bear. Otherwise, it's not. And from the victim side, you can say, if I can identify someone else who's connected to it from the point of view of responsible agency, then it's that person's to bear. If I can't identify who that is, then it's mine to bear. So it's mine to bear if I can't, and for the defendant, it's mine to bear if it's true that, or actually, if someone can show that, it's mine to bear. Right? Those are ways of thinking about tort law, both of them, that take the guiding principle not to be corrective justice, really, but the theory of responsibility, responsible agency. That is, if you want to understand the law of torts, what you look for is proper ownership, the conditions of proper ownership of losses. Right? You can do it with gains too, but we're just focusing on losses. And the question is, what are the conditions of proper loss? Now, and that the fundamental notion in tort is the notion of responsibility, responsible agency. Now, that is not a corrective justice account. That by itself, it might be an element of a corrective justice account, but it's not itself a corrective justice account. It's an idea that losses should be owned by those people who are connected to them in the right kind of way to charge them as being responsible for them. If there is no such person, then they lie where they've fallen. Not because that person is responsible, but because no one else is. And that's, you can come up with a view and think that you should do tort law that way, and then you can say, you have very good reasons for doing tort law that way. One of them is we want to further the notion of responsible agency. We think that individuals should, just as they secure the benefits of their actions, should absorb the costs of their actions wherever possible. And this may have all sorts of other additionally desirable consequences, like internalizing externalities or something like that. And so the first thing to note is this is a way of thinking about tort law or anything from the point of view of it being based upon the idea of responsibility. The fundamental idea is responsibility. In fact, if you read Honore, you get in Honore the combination of a mixture of responsible agency, which has a lottery dimension to it, and it's about fairness of having losses imposed upon you as being treated equivalently to what is the scope of your responsible agency. When bad luck becomes something you're responsible for, it's a function of a fair lottery being applied. It's not fundamentally relational in that regard. And that's why, in my view, it's not fundamentally corrective justice. Now, so two things I want to say about it. First is causation enough on its own to give us the relevant theory of responsible agency? That is the fact that A caused B harm, that there exists the right kind of causal structure between A's action and B's harm, enough right way for B's loss to be his responsibility? That's one question. And the other is it an adequate theory of tort law? Is it an alternative to the corrective justice? Now, the point I obviously want to make is that wrongfulness is necessary for both. I want to say that even if I had the view that tort law was really best understood in terms of the theory of responsibility, as opposed to the view that I have, that the theory of responsibility is part of the right view of tort law, I wouldn't think that causation was the right way of spelling this out. Why would I think that? Well, let me give a couple of examples. Because I think that causation is, of course, interesting, but I don't think it's identical with responsible agency. That is, the question we ask in terms of responsible agency is the idea is, how am I connected to the things in the world that happen such that those things are mine to answer for, which is quite apart from the question of to whom do I have to answer, but appropriately mine to answer for. That is, if I were made to answer for them, I would have no claim of being wrongly ascribed responsibility for it. I mean, and so the conditions are, what are the conditions of, the question is, what are the conditions of responsibilities? Now, it seems to me, if we just take a simple example, like Cose's cows and corn, just to take this out of the realm of the things that New Yorkers would know much about. The question is whether the cows who trample the corn are, the way Cose poses the question, it's misguided. He asks the following question: do the cows cause the corn damage, or do the corn cause the damage, to the cows? Because when you make the cows pay, then there's damage to the rancher, and is that damage something that the corn causes? Well, this is just a bad way to think about the problem, but he was onto something, right? He just had the wrong conceptual apparatus for expressing what he was onto. What he was onto was, we're asking a question whether the fact that cows trample the corn, which is the causal question, whether that matters from the point of view of whether there should be a cost of ranching or farming. The causal question is resolved. The causal structure is clear. The cows get out and they trample the corn. They cause damage to the corn. The question is, should that cost be a cost of ranching or farming? And that cannot be answered without answering the question, who has a duty, whether the rancher has a duty to fence in or the farmer has a duty to fence out. So only when we can answer the question, who has a duty to whom, can we figure out which activity it's a cost of, right? So that is, who's responsible for it? The question of who's responsible for it, that is, who has to answer for it, is a question of what regard does each owe the other with respect to the relevant activities. That's the claim. And it's not resolved by the causal question. It's a normative question through and through. So I actually agree with Carlos that a better life is the life in which you are judged not just by whether you have a good character or not, and whether you've meant well, but what things in the world, are different in the world in virtue of your actions. What difference have you actually made? And which things are yours? Which things can you take credit for, and which things do you have to answer for? And that seems to me something that requires us to have a view about what duties you owe other people. So if you have the duty to keep your cows in, then when the cows trample the corn, that's something you're responsible for. If you don't have that duty, and the farmer instead has the duty to keep the cows out and doesn't put a fence up, then your cows cause the damage, but it's not something you have to answer for, it's something he has to answer for, He's responsible for it. Why? Because he had the underlying duty. So I think that the fundamental notion is the notion of duty, right? Rather than the notion of causation. Now, I think that's the notion of wrong that I use, that I employ, is connected to this notion of duty. It's not connected to culpability. It's connected to what is it that you owe with regard to the interests of others in undertaking the activities that you undertake. And it's that notion of failing to comply with that is the notion of wrong that I emphasize. Not culpability in your action, not, it's this relational duty that you have to others. And because the duties that I think are involved in tort law and in corrective justice are relational, it's the reason why I think that tort law is helpfully understood in terms of corrective justice. So I think that, so I would say two things then. That the account that Carlos offers by emphasizing causation is an alternative account of a theory of, say, tort law that emphasizes the notion of responsibility, but articulates responsibility in terms of causation, rather than articulates the notion of corrective justice. I think both as an account of responsible agency, the notion of duty has to enter and cannot be eliminated. It's ineliminable to the notion of responsible agency. And that in order for it to be a theory of corrective justice, you need a notion of duty. And the notion of wrong that I'm using is connected to that notion of duty. So that would be my response.
Okay, now we can open the debate. I shall only give priority
Yeah,
to
Carlos goes
Professor
first.
Rosenkrantz if he...
I think I have to read the paper again. I have to read myself again, but I mean, the question here is not definitional.
No, I don't
We're not
think-
discussing about words,
Right.
right? So we're discussing about what is the most fundamental notion. I mean,
Normatively.
yeah. And it seems to me that, that the only way in which we could adjudicate this discussion is by resorting to our basic intuitions in sort of canonical cases. And again, for me, in order to explain Vincent, you need to make comings and goings that, you know, it's difficult to see what was wrong there.
Trespass.
Well,
Trespass. It's a trespass. I don't see how it's anything but a trespass.
Clear breach of duty.
Yeah.
Clear breach of duty to the landowner. It's just that you were required by ethics and law to perform it.
yeah, but I don't know how you explain compensation out of that, because it's, I mean, and I will contest the idea that it's a trespass case, because you cannot exclude. The court says you cannot prevent the ship owner from docking the ship. So, and I would say we will all agree with that.
Yeah.
Trespass is, I don't think it's a real trespass case. It's a case where you cause harm, and we don't have a powerful reason to shift the harm to someone else than you because you caused it. And I think that's a very elegant, simple, straightforward way to put it, which shows, I think, that corrective justice is not about correcting wrong, but about correcting harms. Obviously, you face difficult cases, you know, your bankruptcy cases and whatever, but I think you could provide principled ways to solve these cases.
What if I said this to you? In Canada, Vincent comes out the exact opposite way.
It was a wrong decision. I think it
Well,
was
wait,
a
why not say
canonical
that?
case. I mean, we have to start from a
There are also
canon-
English cases that...
Come the other way.
It doesn't matter. I mean, I think we will all agree that that's canonical, that something is missing, normatively speaking, if the owner of the dog does not get compensation. And that's a fixed point, obviously.
We have a
So this was really the line of questioning I wanted to pursue with you, Carlos, because, I mean, it seems to me you're engaging here in a little bit of overkill. You're attacking something that you don't need to attack in order to study you can.
Yeah.
I believe that, first of all, I believe that causation is really central, and I believe in strict liability, a lot of it, and I don't think there is any principal objection to it. And I believe that there is corrective justice in unjust enrichment cases where there's no wrongdoing.
Yes.
All of that.
Yes.
So here's so far so good.
Yes.
Nevertheless, Vincent and Lahiri can be analysed intelligently in two different ways, and you're choosing one without, I think, enough motivation to choose it. So one analysis is the one that is favoured, for example, by Tony Monterey, who says it's a class of unjust enrichment case. You're paying the charge for the use of the pier, which is required of you by law. You would have had to pay the charge had you been able to negotiate it. So there's a substitute charge. This is a classic free acceptance case in the law of unjust enrichment. The other interpretation of the case, which happens to be the one I favour, says it's a straightforward trespass case. It's a breach of duty. It's a strict breach of duty. There's no fault element in it. It's therefore straightforwardly an example of the causal responsibility you're interested in. Nevertheless, it does involve wrongdoing. The point is that it's justified wrongdoing. And that's not even paradoxical. All the time I breach duties to people when I have no alternative. Because breaching a duty and doing the right thing, as I said, justified thing, are two quite independent properties and actions, right? So even in the promise case that I got from McCormack and McCormack got from Hare and so on, in that case, the kids go to the beach. I have no alternative, no justified alternative to breaking my promise. Nevertheless, I break my promise and I have to perform my promise. So it's another classic case where doing your duty is morally unjustified. And the way you presented it in the paper, you made it sound like that was an unintelligible juxtaposition, which seems to me to be too strong. It may not be your favourite interpretation of the case, but it's a perfectly reasonable interpretation of the case. It's one of two rival main interpretations in the literature. I think it would be saying too much with it to say that that isn't an intelligible interpretation of the case. And it doesn't even aid your main line of argument, because your main line of argument can be supported quite independently of your interpretation of Vincent by showing that there are free acceptance cases anyway, some of them where there's no wrongdoing, unjust enrichment cases, and strict liability cases, rather than Fletcher type cases, all of which help to show the centrality of causation without committing yourself on the Vincent interpretation question.
Okay. Well, I think it's possible, but I think I will want, still to be to say exactly the same thing I said, because your argument entirely depends on the continuity thesis.
Well, not about this. About Vincent, it doesn't.
Yeah, because you have to explain that the breach of the duty of trespass turns into the obligation.
That's not why I interpret Vincent the way I do. I interpret Vincent the way I do because the court said it was a trespass case, and if the court says it's a trespass case, I'm prima facie inclined to agree with them since they're in charge. So that's a much simpler reason. Now it happens that then coincides with what I think about the rationale for paying damages, but I can defend a corrective justice rationale for paying damages either way. So I don't have a horse in that particular race based on the continuity thesis. My horse is just based on the fact that I'm a lawyer too. And when it's a trespass case, I say, okay. Okay.
I have my 2 cents on Vincent, but it's part of what I'm going to talk about tomorrow, so I'm not going to preempt myself. But basically, I tend to agree with Carlos about the critique of Jules about where's the wrong here. But in terms of methodology, I think again, to some extent it's an overkill because there are so many other cases in which causation is not enough that I think that you need to explain more than Jules needs to explain why there's no wrong in liability without wrong in Vincent. So this is one point. I have 2 specific points about the bankruptcy example, about your answer to the bankruptcy example, and then one comment about your duty of, the promise to the kids example. So, you, towards the end of your paper, you say that the responsible freedom is the explanation why there's no liability in said that it's not sufficient, but when I read the paragraph on page 12 and then your analysis of page 15, it seems to me that I can't see a reason why you criticize her, and then your interpretation of the responsible freedom seems to me very similar to what she explained, and you seem to reject it. So this is one point. The other, which perhaps is less crucial for your argument, but you seem not to concede the point that there is a causation here. But then again, I think the analysis needs to be more careful between factual causation, which obviously exists. I guess what you want to say is that there's no legal causation in this text, to Jules' point about the issue of duty. But then, I guess Jules could tell you there's no, if you like, legal causation, proximate cause, because there's no duty in this case, because there's no fault. So, I think this is some kind of a response to that. And then the part of the paper that you say that your wife would have as it seems that you suggest that she would have the same degree of duty that you have. So first of all, it's not clear. First of all, it's not that she has an obligation, because it might be just a matter of a prudence and self-interest, to meet the frustration without her having an obligation. Second, if she has an obligation, it doesn't necessarily mean that she has the same degree of obligation that you have. And third, if she has the same degree of obligation, it might be due to some concept similar to vicarious liability due to the partnership of you bringing children, but it's still parasitic on your duty.
Let me start with the last comment. I think the fact that my wife has reason, I wouldn't say an obligation, reason to alleviate my kids' frustration, somehow undermines, I think, the aspiration, explanatory aspiration of the continuity thesis. Because the fact that I have to do something doesn't show that something follows entirely from my breach of my promise. Because my wife also has to do something. Something else has to be said. And I think everything you could say begs the question in favor of the continuity thesis. Begs the question. Because I would say it doesn't follow from the fact that you had to honor your obligation, as John thinks, that you had to compensate for breaching your obligation. It doesn't follow. It just doesn't follow logically, and normatively, I would say it doesn't seem to follow, since I can point out that my wife also has a reason to do something to alleviate my kids' frustration. So that's pretty much my point here.
That doesn't mean that you don't have a reason to. Your
it
reason
means
might
that my
follow from the
reason,
first one.
I may have a reason too, but you have to say more about where that reason come from, because I would say, well, my kids are frustrated, I have a reason to alleviate frustration. You have to say, your reason follows from your breaching your promise.
That's the continuity thesis.
Right, but you have to, you have to say more than say it.
Yeah. Carlos, I think your wife is more sweet-natured than mine. My wife would say, you let them down, it's your problem. Which is why I think the continuity thesis is appealing, yeah? Because that is a natural thing for somebody to say. Of course, in partnerships it gets a bit more complicated, but that's a common reaction. You let them down, you sort it out. Yeah?
Yeah. But she still had a reason.
But she has a reason, it's just a different reason. It was my reason was that I let them down. Her reason is that they're frustrated and upset and causing a nuisance in the house. These are different reasons, yeah? And they could be connected, because they could be frustrated at me because I let them down. In which case I have both the I let them down reason and they're frustrated, and she has the he let them down so they're frustrated version of that, which is a sort of...
Yeah, I put some weight on the argument, an example, but not a lot of it, because I would say, well, listen, the problem still, you cannot show that that compensation follows from...
Absolutely right.
So I may just apologize.
No.
I said, don't ask for
I thought you were very reasonable and gentle with me, actually, because you said at some point in that presentation, oh, well, even if you don't agree with me about that. So I think it could have been much harder.
But again, I think it's for someone... I think the continuity thesis is something we usually adhere to without thinking too much about it. And when you think a lot about it, it's not clear that it really holds, right?
No, well, so what I would say about the point on which I think you have a point, namely that it doesn't follow we should pay compensation, is that of course there are lots of possible things that might be warranted But I agree with all the substance of your conclusions. I'm worried that you're, this is all my fault, because I've sketched the continuity thesis in such a way to show that only that compensation is one among a range of different responses that could satisfy it, and you rightly put me to the challenge, why compensation, to which there must be various sorts of answers undisclosed. But if I could come up with answers about the pragmatics of legal regulation that show that it would be a bad idea to try and substitute beach holidays for beach holidays when people may have changed their minds, and when people should be given now a little bit of license to spend their money to make up for things the way that they like, all those kind of considerations, maybe that would sort of satisfy you that the law is generally thinking about continuity. In the contract cases, interestingly, the court will sometimes give specific performance with no damages in lieu. They'll say it will only give you specific performance, and if you come back to saying you don't want it, it's tough. And that's a very interesting case where they are opting for taking the kids to the beach tomorrow.
So let me come out against the continuity.
Okay, good.
Because there's just too much love here. So I think there are ways that the way it's formulated is that the reasons that ground the obligation, say, to FI, are reasons that push you in the direction of compensating when you don't FI.
Yeah.
But I think that's just not clear. That is, that's like saying, once you have it, here there's two different things here. One is, once you have a duty to FI, then we might think that there's a principle that says, given that you have that duty, when you don't discharge that duty, then you should do something in the neighborhood of it, given the change in circumstances. But that's not how the continuity thesis is advanced. It's advanced about a thesis about what the reasons require. And it seems to me that once the duty has been breached, that's another fact that goes into the set of circumstances that, along with lots of other facts, that might tell that the same reasons applied to might lead us to completely different directions. So it might be the case that when people don't discharge their duty to take other people's interests into account when they undertake various activities, that in the light of this being, say, a widespread thing, the reasons which supported people having this duty in the first place now support closing down the activities or regulating them in a completely different way. So they don't really, we don't know what the reasons actually drive us to when the circumstances have changed. So you could have a thesis about the underlying reasons, and you could have a thesis about the duties, right? And I think if you think about the continuity thesis as a thesis about the duties and what happens when you breach them, what you owe, given a reasonable understanding of the duties, that's one thing. But if it's a view about the reasons which, under certain sets of circumstances, support certain duties, once the duties have been breached, we have to see what the world looks like as a result to see what the reasons actually support.
Well, I don't want to take over this discussion because it's really between you guys to sort this out.
Right. But then I just wanted to say, when I supported the continuity thesis,
you didn't realize how rubbish it was.
Yeah. But I think we're getting closer to good grounds for ending. But I thought of it as a relationship between the duty and the
well, me too. Okay, so when I first wrote that paper that Carlos kindly quotes, I wrote it as continuity of the duty, and then I read my Weinberg again, and I thought a bit more about it, and I realized that can't be exactly what continuity is of, because duties are individuated by the action that constitutes their performance. It can't be that the same duty is now a duty to do something else. Reasons, on the other hand, can support multiple actions. So
yes,
it seems to me that knowing something, you're right that we don't know enough yet, but knowing something about the reasons that I have to do my duty, beyond the mere fact that it's my duty, is the clue to understanding how the reasons could still exist. Now, you made a move in your discussion of it there, Jules, which I hadn't heard you make before, but which I associate with your former friends in the law and economics movement, which is that it's a whole new world move, right? And if you take my view of reasons, then that's not the view you hold. So my view of reasons is that a non-conformed to reason is always there forever.
Yeah.
Right? And so it's not a whole new
But what it's a reason to do.
Yes, and sometimes there's nothing left you can do with it. You just have to die suffering in
comply with that reason.
But they could all loosely, I think this gets back to the discussion with Carlos about whether they really count as compensation. They all loosely count as compensation. In a loose sense, they're all next best things that you can do to mop up. Now we have a more technical, narrower notion of compensation,
right,
in which it's something that can be reduced to some common currency, usually money these days, although it might have been goats in some other era, But there's a common currency idea of compensation, and maybe that's not, as Carlos says, maybe we're not driven towards that, but aren't we driven towards something, some mopping up by the continuity idea as I presented? Don't you always think there's always something to mop up, namely the unconformity of reasons, where the question of what there are reasons to do is admittedly now
right.
open.
So I think what there are reasons to do is what's open.
Yeah.
But you might say they all must be versions of mopping up.
Yes. It's just, as it were, analytically true. This is what counts as mopping up, is conforming to reasons that you haven't impeccably conformed to. They were there. The moment to do what you should have done has passed. Now all that there is mopping up, in respect of those reasons.
In respect of those reasons.
Yeah. So you say, well, there are new reasons. Of course, there are also new reasons.
Right.
But those reasons, all you can do is mop up. So I think that was the thought. And Carlos rightly said, well, that's not compensation yet. And I said, yeah, sure.
Yeah, that's
my hands up to that. Yeah.
But let me go back to your second question. Whether, even though I criticize or think that Thompson's argument is not enough, just exactly the same. I think I'm not. What I have in mind is you could exclude liability in the case like the one of his bankruptcy, without referring without using Thompson's argument. Because Thompson's argument is that causation matters because freedom matters. Because we want to have freedom to plan our lives, right? So I don't want to be called to compensate the harms I did not cause, because that will undermine my ability to plan my life. I have a different idea. I think my idea is that what matters is responsible freedom, not just freedom. Because it's good that I, pocket and the benefits I create and pay the harms I cause. So the kind of rule utilitarian argument I use is in structure is the same Thompson's is using, but in substance is a different thing. For instance, I think that the market is a good case because if the market works perfectly, we are all responsible to some extent, or it maximizes the probability that we will be responsible for the decisions we take. It doesn't show that freedom as such is maximized. Responsible freedom, but it does show that, or we expect that it maximizes responsible freedom. I don't know if this is clear. Is it?
Well,
Clear enough.
there are markets and there are markets. Markets
Yeah,
are
I think ideal.
Yes.
Ideal, yeah. Okay.
So see, this is the idea. This is my point. Take it or leave it. That does when markets don't have externalities. When they do have externalities, the question is there are externalities of what activity? That's a question of we don't know which activity they're an externality of by causation alone. That we need to know what our duties are.
But again, the fact that you may have very difficult cases to solve doesn't show that all are difficult cases. So in some cases, causation it's very straightforward. I think I could shoot back and say, well, listen, as I said, if you think that causation is not enough, and it depends on normative judgment, that's a problem because what we do depends on what we cause. And by transitivity, if that's so, if what we cause depends on what we had to do, then what we do depends on what we have to do, which is just unintelligible. So there must be some chord where what we do does not depend on norms.
What we've done does not depend on what we've caused. In part it does.
It depends on certain descriptions are appropriate in certain
Under some descriptions.
Under some description, you're having fun now and you're giving a lecture and you're criticizing Jules, you're defending yourself, and it depends on what is our interest on the normative context. Because
Some idea that you could describe the word, descriptions are
miles an hour, and you say to him, hey, you're being negligent, and he replies, no, I'm having fun. Yeah, they're both true,
Again,
but only one description is normatively relevant.
but if I punch your face,
You really want to do it?
No, I don't want to.
Yeah.
You know, there's a favorite description of it that everybody will feel it's the same one. Obviously,
Because of the normative context.
Yeah,
obviously depends on
If you interpret
assumptions and practices,
practice, no.
but they are taken as facts. They are not normative in the sense that they determine what we have to do. Obviously, they are expectations of people have.
But look, if some guy robs another one's girlfriend, and the first guy commits suicide, causation does not define. Even if you can prove that what caused his committing suicide was that he lost his girl in hands of another man, causation does not define what I did, the other guy did.
If I may add just a little remark, it seems to me that this results from a conflation between norms on the one side and a description of a responsibility to another. We cannot construct, of course, the concept of cause by deontic judgments or norms simpliciter. But to reconstruct the position of the skeptic says that the concept of cause depends on what we consider causally relevant. And so in this sense they put the concept of normativity inside the concept of cause. But this has not to do with the principle that of course we can reject from deontic logic that what we do cannot follow from what we ought to do. These are two different things, I believe.
Okay.
I don't know. There was a third question?
It was the first one, but I forgot it.
No, it's just I think it does tell what we just said now, that you pointed there was no causation. I think it wavers between factual causation and legal causation, which begs the question of whether there's duty or not.
Okay. We have Diego question.
You will want to hit me in the face. You really will want. Now, I agree with John's remark regarding your position is too strong, maybe too strong, because you say that in the dog case, the sheep and the dog and everything, in Vincent, that there is no reason whatsoever for the sheep captain not to dog the sheep. No reason whatsoever for the captain not to dog the sheep. There is no reason whatsoever, and that's very plausible. I would say that if there are two dogs, for example, I should choose the more oldest one. The oldest
that's
one.
That's a different example.
No. I should say that even if there is one dog available, maybe distributive justice consideration comes into play. And if I'm rich and this is one of my many sheep and this is your only dog, maybe I have a reason not to dog it. Maybe. No reason whatsoever. I think that the best reconstruction here is Thompson's. That is the same, I think, that John was using. You could say that the dog owner has a right that his dog not being destroyed. You could say that. Prima facie, at least, the dog owner has a right that his dog is not destroyed. And the only way you can respect that right is by not destroying it. The only way. Once you dog the sheep with the dog, and the dog is destroyed, you violated that right, you infringed that right. Even if you do it justified.
But it depends what kind of right the dog owner has.
Yeah, there are two
Maybe
One
if
is
you describe the right, you have the right to exclude everybody by the
No, I don't mean,
when
even if you don't have anything, you still have reasons not to aggravate the harm. You still have many reasons because there is a moral residue. The point, Thompson's point, is that there is a moral residue. If you have no reason whatsoever, what take compensation? I have no reason whatsoever.
You cause harm.
So you have a reason. Because harm is the kind of, at least for some...
Not because you did something wrong or because the dog owner had a right that you didn't do something.
Okay, let's say you insist on this idea, then you have to say that
from justified harm to lawful activities that cause harm. You could say that justified harm is a lawful activity or not. You should say so.
In Vincent, yes, I would say, and I think
In general,
justified
justified activities are lawful activities.
are
They're not lawful. They're not forbidden. And most cases of civil liability are for lawful conduct. So the victim never has a right not to be harmed. And if the victim never has a right not to be harmed, then rights are just rights in compensation. So you adopt the view that law is a price system, not a system of accountability, as Jules is saying lately. You commit yourself to the same account that law and economics commits, that people, the rights we have are just the price someone has to pay if they want to use it. So autonomy there and responsibility evaporates. You cannot sustain that the final or the most basic idea under your conception is responsibility when you adopt the theory of rights as prices. We have to pay to use someone's liberty. And I think that's very critical in your theory. And thank you for this paper because I finally got what is wrong with your theory.
I don't think, let me think about this. I don't think I need to, first, when you speak about having the right not to be harmed, right, is it something more than just a way of talking? Because in some circumstances you don't have that right. For instance, the dog owner didn't have the right not to have his possessions or property harmed. He didn't have that right. He could not exclude. I don't know what it means.
Well, that's not the same thing.
Well, it's true.
He could not protect his right by excluding.
Yes.
He could protect his right in other ways, but he couldn't
You need
protect it
just
by
one valid
excluding.
claim to have a right. One valid claim. And compensation might be that valid claim. So it's meaningful to speak about rights if you have one valid claim.
Well, I think you could describe it both ways.
Yeah, but if you describe it in your way,
He just wants to point out a cost of your describing it
yes,
in your way,
the cost is that
which is the key thing is the harming.
Yeah.
And the causal connection to the harming. If the causal connection to the harming is the ground of the compensation, and it's the ground of the compensation because you kind of own the negative consequences as well as the positive, then everybody who's a victim, right, is not standing on rights when they make a claim. They're actually being vulnerable to your exercise of your freedom to harm them, whether justifiably or not, provided you compensate them. That's
provided
the
you
thought.
pay the price. So
That's
autonomy
the thought.
evaporates. The idea of autonomy.
There's nothing that they stand on.
But again, what is wrong in Vincent? Because I would say it's a kind of price paying.
No, the
So
idea
you
is
have to
that-
explain
no,
again.
they did
Wait.
with the storm.
You have to explain where the wrongfulness lies in the case like that.
Yeah, I can explain it. The idea
Where?
is that the storm is not my business as a dog owner. It's your problem that you have sheep. And now you are charging me for the cost of having sheep. Change business if you don't want the
I would
sheep.
say that too.
So that is what is wrong. You're making your problem mine.
So I think this really is a bit of a terminological dispute because wrong has many different uses, right?
Right.
And so and this is the thing that Jules points out in Risks and Wrongs and Elsewhere, and he comes up with a distinction, if I recall right, between wrongdoing and wrongfulness that's
Right.
made to mark this. But this is just a naming, right? But it's because talk of wrong carries many connotations, and one is breach of duty, and the other is unjustified. And so the challenge that's being put to you is why you think these things are as closely connected as you do. Many people think, as I think Diego thinks, and I think, and Jules thinks, that there's no really very close connection at all between the question whether something is a breach of duty and whether it's justified, with the result that you can have unjustified breaches of duty, unjustified performances of duty, you can have breaches of duty that you had no justified alternative to. All of those things are all on the table, but you have quite a strong, what shall we say, univocality in your thought of wrongness, such that you demand something else from Diego than just that, which is that it's a breach of duty, but a perfectly justified one to which there was no justified alternative. So just imagine a conversation with the around the radio in his ship. All right. So the storm's coming, right? And he radios back to base, and base says, "Go to the nearest pier." And the guy says, "We've got the nearest pier here, but it's not one we've got a license to stop at. Right? That's the reason not to go there. Right? Never mind, it's an emergency. We do this in an emergency. We'll worry about that later." Okay. So the ship's captain is already taking account of the fact that he has a duty not to go there. He's factoring it into his decision, and he's being told by his boss, "Well, it's a breach of duty case, but this is a special instance where we are justified in breaching the duty."
But I don't think he has a duty not to go there. He has a duty to pay.
Oh, well, okay, that's another analysis.
Yes.
But the question is, should we logically exclude Diego's analysis, which is also mine and Jules's, which is he also has a duty not to go there. He has a duty not to go there, which nevertheless he would be unjustified in performing. Right?
But I mean, in order to explain Diego's and your reaction, you have to say that there's a residue in the case.
Yeah, yes, for sure.
And the residue is the captain is doing something he shouldn't.
Well, that's right. He's breaching a duty.
But I would say there's nothing like that. I mean, he should in a case like this, it's a sort of in this case it's sort of price, because it doesn't really make. We would not think that what the captain did is not even objectively regrettable.
Yeah. But Diego's point, which was I think was also my first point, which I may not have expressed right, was that may be true. You may be right in your analysis of the case. The court itself may have got some of this wrong.
Yeah.
But do you need to commit yourself to that to make the case against Jules? I think not, because you're committing yourself.
No.
You're committing yourself to the thesis.
I don't think there's a case against Jules.
No.
There's a case against Jules.
Okay, the putative or purported case against Jules. But the maybe it was a case against me. I've forgotten. But the key thing is that you don't want to go so far as to say that the position that Diego just took in the analysis of the case doesn't make any sense. That's too strong on any view. And if you have to say that in order to rely on the medicine case, I guess it would probably be better not to rely on that case, but to rely on another case instead, where the problem of counter-interpretation doesn't arise. I think that was the thought I had.
Okay, yeah.
Because otherwise I thought that everything ran smoothly. I just thought in the middle there was this contentious extra surface issue where Vincent was put on the table.
Well, I think Diego's point is strong enough. Diego's point is, if you think that so it's one thing to say, I'm unconvinced that you need the notion of wrong to do the work. That's one kind of thing. When asked the question, what does do the work here, right? Then look at what the consequences are of that thesis. That's Diego's point. Diego's point is if what you say does the work here is the fact that there's the right kind of causal relationship to harm. And this goes back to my earlier remark that you're viewing these things in the terms of the theory of responsibility. This is something you own, just like if you had provided a benefit by having the right causal structure to a benefit, that it would be something you own. So you're just taking back what you own. So you're paying the victim of this as a way of taking back what you own, not as the victim demanding that you make good his loss, standing on a claim of right. So the victim is never standing on a claim of right. He's only party to your taking back what you own. So you make your way through the world taking the goods and the bads that you own, where the victim doesn't stand in any spatial relationship to putting demands on you that you take it back for a certain kind of reason.
Well, I think
right?
at the end of
That's the thought, right? Is that the thought? And it's hard to square that. Diego's point is it's hard to square that picture with the notion of responsible agency, because part of responsible, freedom of responsible, is recognizing the claims of others and acting on them, treating the claims of others as constraints on your action. That's the thesis. As
that's
interesting.
Yeah.
Okay, that's the question.
Very short, Carlos. One question is, how does your account, how would you account for liability for omissions, other by making reference to breach of duty?
for emissions.
Omissions, yeah.
Omissions.
Yes, omissions. Because I take your account to explain the straightforward cases where I caused something by doing something. Or how about when the law makes
happened in virtue of my omitting.
Yeah.
Right, but I have a different relationship with the consequence. Once it's something that happened, and in the other case it's something I omitted.
Yeah.
Well, I think omissions, and I think it's not different with actions. Depends on expectations, on paradigmatic cases. I would say. I mean, my idea of causation requires the idea of paradigmatic case. There are paradigmatic cases where obviously the idea of a paradigmatic case somehow requires what people expect us to do. But that also happens in the case of actions, not only in omissions. But that's different from using a normative, sort of saying that what I do depends on what I have to do. What I do depends on what people expect me in general to do, which is different from the more, substantive and loaded argument that claim that what I do depends on what I have to do. Is it clear?
No, well, I will
I would
come
say
back and
regularities. You have to
yeah.
resort to regularities or to paradigmatic cases.
Okay,
not
not-
expecting certain circumstances.
Okay, so
But that's not. It's not normatively. I mean, it doesn't depend on the normative theory of what should actually happen. That's a matter of fact. What people, as a matter of fact, happen to expect me to do. That's a fact.
Okay.
Well, I think there's you're trading on an ambiguity in the notion of normative here, right? So I think when you have our actions, which are ontological things that involve certain states of mind and bodily movements, but then we have the descriptions of the actions, right? And the descriptions of the actions some are apt and some are not apt, depending on the circumstances. And so there are normative factors that bear on the descriptions that are thought to be apt in some set of circumstances. But that notion of normative, right, is not the notion of normative that's involved in what I ought to do.
Right. Yeah.
Right? So that blocks the bad inference. When people say that the question of what I did is normative, they mean to be saying it in this sense. The description of the action, which is apt for the circumstances, is apt in the light of reflecting upon interests, purposes, relevant kinds of considerations, and those are all normative considerations. They're not normative in the sense of what I ought to have done. And so there's normative at one stage, and that act descriptions are normative in this sense, in that, so when you say expectations, you're appealing to a norm, particular norm.
Yeah, absolutely.
You're appealing to a particular norm, but that is the appropriate norm. We would disagree about whether that's the appropriate norm, but still, we're all using the term normative in